Hi, this is Professor Chad McGuire, and I'm here to provide you with an overview of the concept of the hierarchy of laws. Now, what I mean by the hierarchy of laws is, first of all, I want to be sure that what I'm about to discuss you understand is not definitive. It's a conceptual way that I have developed to try and understand the relationship between the different types of laws and law-like mechanisms that we use in the United States. This is mainly geared towards the federal level. It also has application in most states at the state level as well, but here it's geared towards the federal level. And I'm coming at this from a large scale sort of policy orientated view. So this certainly has applications for students of the law, but it's not going to get into some of the details and minutia. You can look at some of the other videos that I have on my YouTube channel to help you understand some of the greater details related to the hierarchy of laws and some applications. But this general discussion certainly has relevancy to those that are studying policy, public laws and policies in general, administrative law principles. And because of my background, some discussion of environmental law, environmental policy, and also to a degree, some ocean law and policy that is discussed in one of the courses that I teach. But it has relevance in many other areas. And I'm certain that if you're looking for a general overview and understanding of how our laws are effectively implemented, not necessarily created, but implemented relationally to each other here in the United States, this should be helpful. So if we were to think of a hierarchy as sort of a pyramid, where the top of the pyramid represented sort of the highest level of law, the law that would trump other laws or law-like things, government actions, for example, the type of law that would have the greatest say over the greatest number of things that happen in the United States, it would be the Constitution, the US Constitution. It is, for all intents and purposes, the supreme law of the land. So we can look to the Constitution to understand the relevance and where other laws might sit. And the Constitution, it's not just the original Constitution, it's a number of amendments. And we know that the Bill of Rights, the first 10 amendments to the US Constitution, a lot of what people talk about when they think about their individual freedoms vis-a-vis government action, what protects individual citizens and people that are in the United States from government action against them, they often, they talk about free speech and free association and maybe some Second Amendment rights, Fourth Amendment, due process rights, rights against cruel and unusual punishment, Eighth Amendment. I mean, many other, what they're talking about are the first 10 amendments, and they sort of imbue that as these are our constitutional rights, and that's true. The Constitution itself, though, sets forth in three main articles the sort of separation of powers by defining the branches of government and what areas of law each branch of that government has relegated to itself. And, Article 1, Article 2, Article 3, those three main articles create our government writ large. Article 1 being the legislature, our US Congress, Article 2 being the executive, the President of the United States, and all of the executive agencies. And that really gets into administrative law principles, those that carry out the will of government and carry out the day-to-day operations of government. You think again, and I say these in other videos, so for those that have watched these other videos, you'll know, but those who haven't, you think of what you deal with on a daily basis at the federal level. I mean, not on a daily basis, but if you're the Social Security Administration, for example, is a, Article 2 executive agency, the Internal Revenue Service. In the world that I live in, the Environmental Protection Agency, the National Oceanographic and Atmospheric Administration, NOAA. There's many different organizations and groups at the state level. Most of you deal with either the DMV, the Department of Motor Vehicles, or the RMV, the Registry of Motor Vehicles, or some variant of there. That's something you deal with on a regular basis, but most of us have the interactions we have with government are usually through administrative agencies. Well, they're created and their power derives out of Article 2 of the US Constitution. And they certainly can't do Article 1 activities. So they can't create foundational law themselves. Agencies and the executive cannot, right, create law, because that's Article 1. That's what the legislature is for. And then there's Article 3, which is the judicial branch of government. And they really, decide cases and controversies between effectively the other branches of government and government to citizens, usually. So the judicial branch is, resolving disputes between citizens, among citizens, and certainly when it comes to constitutional issues, talking about or assessing the extent of agency action, and also sometimes when there's problems or difficulties between the legislature and Article 1 and the executive, Article 2 branches, and sometimes even between those branches and the court itself. So resolving disputes where challenges of court opinions or where the court's jurisdiction lies, sometimes between the other branches of government. So the Constitution sits at the top, not only because it's the thing that we talk about and think about in terms of fundamental rights and protections for individuals against government action, but also by setting forth the relationship between the different branches of government. Below the Constitution are the laws. And this is really what I mean here is the Article 1 legislative enactments. So this is when Congress gets together, has a proposal, develops a bill, and then that bill goes through a process where it, gets agreed upon by both chambers of Congress, both the House of Representatives and the Senate, and then moves its way to the executive, to the president for a final signature, and then becomes law, that process we have in place. But that's what I mean by laws. And, of course, there's an analog at the state level where, of course, states engage in the same process, and even lower levels of government, municipalities, through the passing of ordinances by elected officials, whether that's city councilors or, others that are elected to represent and create, effectively act as a legislative body at the local or municipality level. And it works at the state and certainly at the federal level. So we have the Constitution and we have laws. And the other thing that you can see here is there's a relational component. And what I mean by that is you can see that the Constitution, the triangle, is smaller than the body of laws. And that obviously makes sense. It should be a lot smaller. But the idea is that as we move down the hierarchy, we can see that there's probably a lot more laws than there are. There are a lot more laws that are created than there is Constitution. There's one US Constitution, has a bunch of amendments and that sort of thing. But the Constitution in and of itself is it's smaller, but it stands above the law. So no law that is created in the United States can violate a constitutional principle. The Constitution is supreme in that way. It has a hierarchical, level of order to it, and being over the laws. So then the question is, what's below laws, if anything? And what we have here are regulations. And this is the world where most of us live in. This is the world where most of the things that we have to do, most of the things that we're subjected to in terms of government intervention, government requirements, prohibitions on our activities, they live in the world of regulations, requirements, tax bills that we have to pay, the process of payment, assessments, all kinds of things that we can think of. They live in the world of the regulations. And by definition, or as a result, regulations are often derived from the laws. So we have, and this is, if you look at administrative law principles, and I have a sort of overview of administrative law, particularly things like delegation and some other videos about how administrative regulations and administrative entities create regulations, sort of videos on that. And you can look at that, and that will tell you that laws often create enabling statutes for the executive. So Congress creates a law and then delegates the implementation of that law to an executive entity. And then that executive entity, in the process of carrying out whatever that law says, has to often engage in creating regulations, or something we call quasi-laws. So the reason for this is practical. For example, Congress passed the Clean Air Act, and the Clean Air Act requires that government set regulations that define what is clean air, what makes air clean, what's an acceptable level of pollution, and then mechanisms for controlling and regulating things that might cause pollution. It might cause that air quality to be degraded. Now, Congress could do it itself. I guess in theory, Congress could be responsible for setting those limits, like for defining what's a pollutant of the air, and then figuring out how much of it can be allowed in a particular airshed. But that's really hard to do. And it requires a lot of expertise. And the people we elect to be our representatives, generally speaking, they're not experts. They're really not that, they might be experts in certain fields, but they're not experts in everything, far from it. And so it's much easier when you create a law like the Clean Air Act or the Social Security Act or the Internal Revenue Code. It's a lot easier to delegate the responsibilities for implementing those laws to experts. And that's, if you have heard of the term bureaucracy, that's one of the reasons government is, has a bureaucratic aspect to it, because the executive is the branch of government that then is responsible for implementing these laws and the will of Congress, so to speak, which should reflect the will of the people. We assume that, for example, Congress would only pass a law to clean the air because the air was a problem. It was getting really dirty and was causing a lot of, health issues for the people that Congress represents. And so through Congress, the people want cleaner air, and therefore Congress responds and creates something like the Clean Air Act or many other laws that we can think of. And in doing so, is sort of implementing the will of the people. And then it's up to the executive branch and the experts within the executive branch to implement, both to be created. So for example, one of these environmental laws creates the Environmental Protection Agency, an enabling statute creates the Environmental Protection Agency, and then funds it, provides it with funding, because Congress understands that we need to do these things, and the executive branch is the place to do it, and it needs to have resources in order to hire and sort of, create the bureaucratic capacity in order to properly implement these laws. And when, as anybody who has studied or looked at administrative law, and this certainly applies in almost every field of law, certainly in environmental law, but in many other areas, when the agency receives that new law or amendment to the law or whatever statute that is passed and some new responsibility from Congress, it then is in implementing that will, it often has to create regulations, its own sort of quasi laws. These are not laws in the true sense of law, they're administrative agency regulations. And they go through a process where the agency effectively engages in what they call rulemaking. And often there's different kinds of rulemaking. There'll be another video discussing in greater detail, a separate video to some degree, on the different types of rulemaking that occurs. And this is mostly done under what Congress passed a law about administrative agencies called the Administrative Procedures Act, to give agencies guidance and requirements as to how they go about doing what they do, and particularly when they go about this rulemaking process. And most of the time, agencies engage in this sort of quasi-formal process, or I guess informal process called informal rulemaking. And most of us know this at the local level. It's a notice and comment. Anybody who's ever, I don't know, in Massachusetts for sure, if you had a neighbor, if you and your neighbor live next to a wetland resource within a certain distance of your home, and your neighbor wants to do something on their property, and it's going to come within a certain distance or come up close to that wetland resource, that neighbor has to file with the local wetlands board, file effectively a notice and get a permit in order to engage in whatever activity they want to do, whatever building or development. If they want to expand their house, they want to put up a shed, they want to dig out some of that land. And part of that process is you have to put your neighbors on notice. And most of us, even if it's not related to wetlands, anybody who's a landowner at the local level might have, over their experience, been in this situation where they've received notice of a hearing, a public hearing about a proposed activity from one of their neighbors. And certainly you've probably seen this in other contexts, even if it hasn't dealt with you directly. And this is part of the process in which agencies engage in their rulemaking. And those approvals, those individual approvals, are these sort of quasi-individual rules, not a wide standing rule, but a decision about how to implement, a statute, a statutory requirement, or even a regulatory requirement from the state level at the local level. Anyway, agencies engage in regulatory rulemaking to create these regulations, and they far outweigh, in terms of size, as is represented here, the laws and certainly the Constitution. Those regulations, of course, as those laws, as I indicated earlier, as the laws have to be in compliance, cannot, violate constitutional principles. The regulations also cannot violate constitutional principles. It's part of the hierarchy. And those regulations must be within the delegation. They also cannot violate the scope of authority granted to the agency under the law. And I have you can see a video about that, about delegation and what that means in terms of scope of authority. But the point is, the agency must act within the law. And if it does not, then it violates the law. And therefore the regulation or the act in that instance is invalid. Therefore the law is, hierarchical, is higher up than the regulation. And certainly it also has to be constitutional, as the laws have to be constitutional. One thing that we can add to this is as I've been hinting at maybe expressly, is that this process, this hierarchy exists not only at the federal level, but also at the state level. So every state in the United States has its own state constitution. It has its own legislature, and it has its own executive agencies, entities. And its constitution defines the limits of the legislature in the state, and the legislative delegations for the agency actions define the limits of the regulations and how those regulations apply. There is something that's important to at least mention, and it's called the Supremacy Clause. And the Supremacy Clause under our Constitution says that if there is a direct conflict between state and federal law. So sometimes there are situations where there is a federal law and a state law on the same subject area, and the state law conflicts with what the federal legal requirement is. It directly conflicts. And when that happens, if and when that happens, then the federal law is supreme over the state law. So there can never be a situation where a state law tells you to do something, or allows you, I should say, to do something that a federal law prohibits you from doing, a similar federal law in the same area. And if that ever happens, then the federal law is over the state law when there is a direct conflict. So that's something to remember as well. As far as the importance of the hierarchy of laws, it's important to understand this framework, I think, because it allows you to have a sort of filtering perspective when you're, especially if you're in public policy, but any area, if you're studying any aspect, whether it's law or policy, and within any specific area of law and policy, when you're thinking about the actor, so you're looking at something and government's involved in some way, even if it's a private action, there's government involvement because there are laws or regulations, that sort of thing that private action is related to. And certainly if it's a public actor, then it's directly on point. And laws matter because if an agency is engaging in action, for example, you're wondering to yourself, well, is that agency, does it have authority to do what it's doing? And often the agency can point to, for example, a regulation and say, yes, I have authority because we have passed this rule, see here, and it gives me authority. Of course, you can look at that rule and then you can think, yes, maybe that seems like that rule might give you authority to do what you're claiming you have authority to do. But I wonder if there's two ways to look at this. If the rule itself, as it's written, violates the delegation, if it's outside of the delegation of a state or federal law, let's just stay with federal for now. So if the federal agency is acting outside of its capacity, so the rule itself says it can do something that the statute never allowed the agency to do. That's one consideration. The more nuanced consideration is the rule that the agency is pointing to does not, in and of itself, violate the law, the delegation of the law. So it's within the delegated authority, the rule itself. However, the way the agency is going about implementing the rule, the specific actions it is taking in implementing that rule does violate the extent of the legal capacity that it has under the delegation from that statute. This often can happen when an agency is has correctly implemented or created a rule within its delegated authority, but now it's applying that rule in a way that creates an action that is outside of the statutory delegation, the expanse of the statutory delegation. Certainly, if the agency's action or if the rule itself, in every instance, provides for a constitutional violation, then obviously the rule itself is invalid, and the law that allowed for the delegation of that, the law that allowed for that rule to be created would also be unconstitutional. It could be facially unconstitutional, which means that the law itself as written or the rule itself as written in every instance is unconstitutional, or it could be unconstitutional as applied to the specific facts, what they're doing in this situation. The law can be applied by an agency, whether it's using its rules or the law as the mechanism to claim authority for doing what it's doing. The law can be unconstitutional as applied, and the regulation can also be unconstitutional as it's being applied. So there's two different ways. There's the facial and as applied challenges that we can often see from a constitutional standpoint. So this helps us think about how these different laws and different branches of government sort of interact with each other when we think about the Constitution, the laws that are created under the Constitution, and then the regulations that are created under the laws that enable agencies to create regulations and delegate the authority of agencies to create those regulations. In other works that you do, in other videos that I've created, if you want to look there, you'll find some applications of these principles, most clearly in administrative law, but also in other areas, including, again, public policy in general, environmental law, and environmental policy, and even ocean policy and law as it applies to those unique circumstances along coastal zones and between federal and state waters and that sort of thing. So I hope you enjoyed this overview. I hope it gives you some understanding and some starting points, reference, or even just reinforcement of how these laws interact with each other under this scheme of hierarchy of laws. Thank you very much.